putting on your hat as a mediator and I guess also as an expert witness, another question that we have from the floor is to ask you if you've experienced any development or change in the way the courts assess delay claims.
There's always changing, but there is some pivotal sort of cases that have happened in the last 10 years and around it. One of the most recent was a White Construction case out of Sydney, which has been grabbed by numerous people, but I might just make just an initial comment around that. I know the expert who assisted in that in terms of the judge. But that case was a common law case, which means as opposed to a usual construction contract, where there's an EOT provision, and that then guides the court on how this extensions of time should be and delay should be assessed. White Constructions was quite different to that because it wasn't about a construction contract per se. It was about a general damages claim. That would then, if it, under a general damages claim, you'd have to then prove it with causation, which is an as-planned, as-built exercise to try and prove that, but for the events that you're claiming, you would have been caused the damage that you're alleging, as opposed to a construction contract, which in the case of something like Wicket, which was a more recent decision, which said about how the contract was structured and specifically what methodology should be used in the calculation of extensions of time, for instance. They use what they call a prospective method under that contract, which means a forward-looking view. You impact programs based on particular points in time to assess delay, rather than a retrospective, which is looking back after the fact and then trying to reconstruct what happened. So they're quite different in how they sit together. So there's been quite a number of pivotal changes over the time. But say the time impact analysis type prospective view is being less favoured, but it really comes down to the contract. I had one recently, which is express under the contract. It says you will use a time impact analysis. So as an expert, you will use a time impacted analysis. It's what the contract.